This workshop presentation will provide an overview of what is required to undertake a privacy assessment. Based on the Australian Government recommended guidelines, I will take you through each step to show how an individual's privacy can be adequately protected. That is, to satisfy customer expectations by following privacy policies for the organisation, also to satisfy the legal requirements of the Privacy Act, both the current and the forthcoming changes that address data breach notifications. By using case studies based on actual health consultancies, I will demonstrate the detailed steps that lead to a documented privacy impact report. Such risk assessment can determine the viability of new projects before any development has been undertaken. The focus of this presentation will be on the Commonwealth Privacy Act. Established in 1988 and updated many times since, it now has 13 Australian Privacy Principles, or APPs. We need to be aware of other legislation that directly involves health information, for example, My Health Record and the Health Identifiers Act. I gave a presentation yesterday called Striking the Right Balance and pointed out that the Commonwealth Federal Privacy Act does not, unfortunately, cover everybody. In fact, some small businesses are exempt, but healthcare providers are included. But that's only for private. In the public hospital system, for example, it's covered by state and territory governments, and they may or may not have their own privacy acts. So it would depend on the state in question. It would depend on the type of business and the size of the business. And not everyone will be covered except by contractual obligations. And then there are a number of other state laws to be taken into account. So individuals will have to find out what applies to them directly. But for the purpose of this presentation, the Federal Privacy Act and the APPs do provide comprehensive protections that will suffice in most cases. One thing to be concerned about is the new Notified All Data Breach scheme that comes into force on the 22nd of February this year. Not only does it require mandatory data breach notification, as shown by the online registration form here, but failure to act appropriately can result in heavy fines, up to $360,000 for individuals or $1.8 million for organisations. They recommend a number of steps to be taken, as shown in this flow diagram here. Now, the first step is to ensure that governance and security, as in APP 1 and 11, have been applied. Then, if there is a suspected or known data breach, there are steps required to contain it, and then assess the seriousness and the remedial action that's required. Following down, if a serious harm is not the case, then a review is required. But if there is serious harm, as identified by the guidelines, then it's necessary to notify individuals, it's necessary to notify the government, but it's necessary to take the appropriate steps to ensure that harm is minimised in this case. Now, what I'd like to do now is look at a privacy case study. This will involve a privacy impact assessment, or a PIA. One of the steps involved in ensuring that your data is secure, it's recommended that a privacy impact assessment is done by organisations on only new project, or in fact any project where individuals are identifiable. And of course this will apply in most cases with health information. Now, the actual case study involved, I've changed it slightly. I've given a different name, so the company involved isn't identifiable. And I've called it youronlinefriends.com. But it shows exactly what happened in this particular case when an internet-based service was required to assist parents and guardians of children with special medical needs. Now they had a service already, and they wanted to extend it to allow online applications for new members and information updates by existing members. So at the moment they were using paper forms to do this, and they thought an online system would be more reliable and hopefully more secure. So it includes entry of personal information, some of which is highly sensitive about the medical needs of children. And a privacy impact assessment was considered on the privacy through the addition of these new services. Now the areas of concern, or the main areas of concern that were raised early on, was there was a lack of system documentation from a third-party IT service providers. They were using a small IT company, which by itself was exempt from the Privacy Act. And that company handled everything, but did not provide documentation back to the company, the online company, the medical company concerned. They also made use of shared resources like USB drives, Dropbox, shared network drives, etc., because it was an easier way of transferring information. And there was a necessity to strengthen the network security measures in the way that information was passed around. Other concerns that came up were unnecessary collection of some personal information. Now, a lot of companies collect information hoping it may be useful, but then that generates extra risk if that information then is breached, and it was really of no direct purpose for the particular application in hand. They didn't provide any opt-out from direct marketing, and the focus on information security rather than privacy at the annual audits. So the organisation did an annual audit on security, but they didn't consider the privacy issues, which would come out through privacy impact assessments. So they strengthened their firewalls, they strengthened their ability to detect unusual behaviour, but they didn't look at, well, what is it we're collecting, and can we de-identify this in a more to reduce the risk of people's identity becoming available on the web. In addition, there were some practices by staff members that could result in unintentional violation of the privacy principles. They weren't aware of what they all were. There were recommendations regarding the introduction of staff privacy training. They could make use of third-party service providers, yet it's still responsible for the privacy of the customers. So what was happening is that even though they were using third-party providers for some of their services, they still hold the responsibility. So the Your Online Friends company held the responsibility. You cannot pass that on to another organisation. And recommendations in the inclusion of privacy compliance in third-party service agreements. So recommendations, which we'll go through at the end, will show what was came about from this study. Now, a privacy impact assessment, there is a guideline produced by the Australian government and the Office of the Australian Information Commission, and it's a recommended way for ensuring that the privacy has been protected to the level necessary to meet the legal expectations. It should be noted that only a privacy impact assessment can identify flows and associated risks and map against the actual operational working with an organisation and compliance to the legislation framework under which they operate. So in other words, simply boosting your security doesn't necessarily identify where some of the risk can be reduced by knowing where that information is going, what that information contains, and whether it was necessary to hold it in the first place. So a PIA is a recognised way of reviewing new projects and determining the impacts they have on an individual's privacy. It's a recommendation by the Australian government for new projects and for not only legal compliance, to make sure it's acceptable by the community. Analyses the information flows and identify 20 potential privacy impacts in this case. The likelihood of occurrence of each privacy impact was estimated to allow calculation of risk, and these range from high level to low level risks, requiring different actions and urgency accordingly. And a final report provides recommended actions to mitigate against these risks to an acceptable level. It should be actioned as soon as reasonably practical, since many identified risks are evident in the current practice that were undertaken by the organisation. So here's again another flow diagram that shows all the steps involved in a PIA. I'll just magnify that so you can see the steps to the PIA is, firstly, do you need to comply with it? And if you're a healthcare provider with health information, the answer is always yes, unless you're covered by the state laws, and they will have their own legislation to consider, but the steps will still be the same and have the similar outcome. So first question, is a PIA necessary for this project? So this is what's called a threshold assessment checklist, and you determine whether you need to do a PIA, and if you do need to do one, what is in scope and out of scope, and what is the information you need in order to make the initial assessment. From there, we map the information flows. We find out where all the information goes to, and this can be both manual information, paper-based information, things that come by fax, for example. Application forms are done in a manual way and stored, as well as the online system. So when all the information has been defined, we define and analyse the risks associated with the information, do a full risk analysis, and we'll show the spreadsheets for doing that. And then we check the legal compliance against the Australian privacy principles. When that's all been done, we can formulate the recommendations against all the risks and produce a PIA report, which will have the necessary actions to show the way forward. So here is a checklist that shows all of those steps I've just described, and you can tick these off as it's that you've understood the requirements, whether it's in progress and when it's completed. So this is a steps checklist, and I'll show you where these particular checklists and spreadsheets and everything that's been used here are available free of charge and in the guidelines that I provide. So the first thing is the PIA threshold assessment. Do we need to do a PIA? So to understand that, we go through various questions. Number one, will any personal information be collected, stored or used in this project? Well, of course, if there's no personal information, then a PIA is unlikely to be required. But if there's any information that a person can be identified from, so it doesn't necessarily have to have their name, but if it's easy to identify them by other means, then yes, that's considered personal information and they're identifiable. And we continue on to look at the next questions. Having decided that the PIA needs to be done, the next thing is to scope it. You may not be able to read the detail here, but let's just have a look at what's in the out of scope list, for example. So you might decide that some things are in scope, some things are out of scope, and here we're showing the out of scope list, and it might be things like audio video recordings, customer information sheets, minutes of board meetings and so forth. So we want to keep it focused on the important information, and so certain things like marketing and financial stuff may be excluded and covered by different PIAs if necessary. So it's important to understand the scope of the project to ensure that we get a comprehensive understanding of what's involved. We also might flag things for consideration because there are, we're not sure, but it would be a good idea to keep an eye on certain things which, like service level agreements with external clients, to see whether we've covered things correctly and don't introduce unnecessary risks. So having completed that, the step here shows the information needed checklist. So we need to work out, before you can do a privacy impact assessment, we need to gather all the information together. So what this does is it allows the assessor to put in, as you've shown in the blue boxes here, what information is available. And for example, number 2 there, it might say the member's application form is needed to ensure that we know what information is collected about each of the customers involved. And then the information mapping. Now this is a pretty high level information mapping for this particular case study. But what we're seeing here is how there are servers, web servers, data backup databases, that they're kept in different cities for business continuity purposes. They're accessible by the internet, how the staff might access information, how members of the public might access information, and it gives us a sort of high-level information mapping. Now we can take this down to quite detailed levels, and you would do so for a privacy impact assessment to make sure that information that is being passed around your organisation, we know where it all goes. I mean, that can include the backup disks or tapes or whatever's been used, or are using a cloud service for that. You know, we need to know where that information is, because any of that information can be at risk, particularly if it's been stored in a non-encrypted format. Having done that, the next slide here shows the risks that were identified. For example, not a common one, not updating application software to the latest version. And this was considered a high risk. It was likely to happen and had a major impact. Now this particular chart is produced by a spreadsheet. This is a summary. The individual risks shown I'll show in a moment, and show that how they contribute to making up that summary. Now, of course, risks are derived from 2 factors. Sometimes different terminology is used, but basically it's the likelihood of something occurring and the impact when it does occur. And a little bit of detail here is showing how, and it's necessary to determine what you mean by when you say likely, possible, you know, so what's the chance of that occurring, and when you look at impact, you know, what's the damage to you as an organization? How much will that cost you to put right? As I said earlier, we'd look at a detailed risk in this case. We're looking at the risk identified number 2, not updating software, and it was identified that it's likely to happen and it could have a major impact, and therefore the risk level is high. That risk level is worked out automatically depending on what you select for likelihood and impact, and that comes from a matrix. Now, different organizations use different matrices. It doesn't matter. Some of them have high risk, some of them have very high risk or extreme. They have different labels. The important thing is not what the label is, but what it means to you and what action you take as a result of it. So what does a high risk mean to you? What action are you going to take? Does that mean you'll leave it till the next annual audit? Hopefully not for a high risk. What it should mean is that you'll take some immediate action or some action in the very near future to put things right. Together, it might show the Australian privacy principles that apply. This come from a drop-down menu, what mitigation strategy you have, the rationale behind your assessing this risk and initial recommendations as to how to prevent this risk or minimize the impact of that risk. Here's another one, business identifiers that use individuals' names. So rather than using an account number, I mean, quite often it's common when you come to, for simplicity, people are asked to use their email for a login, and their email consists of their name. So you have to think about this consideration and say, was that the most appropriate, or is it better? I mean, people, obviously numbers are, more secure, but they're not easy for people to remember. So you have to consider the best way to label something to minimize the risk of inadvertently identifying an individual. Here's another one here, personal data being disclosed that should have been destroyed in a timely manner. People have a habit of holding on to things unnecessarily and unnecessarily long, and that's against the law. I mean, that is covered under the APPs. Holding information unnecessarily after its usage is, if someone has left the organ, in this case, if a customer hasn't paid their fees and they've been and their membership has expired, then you might keep it for 2 or 3 months in case they change their mind and join again. But after 1 year, you don't have justification for keeping it, for the purpose of the project in hand. Now here's a key question checklist, and there's 10 questions here that make sure that you've covered the really important aspects. And you can fill in, this is a form that can be filled in to say what you know, yes or no, or if you're not sure, so you get a better understanding of whether the key issues have been addressed properly. I mentioned before about risk mapping. Here's a matrix that shows how high risk is determined. Something that is almost certain to happen and has a catastrophic impact is obviously going to be the highest level risk. But something that's insignificant and is very rare or very unlikely to happen will have the negligible risk. And what we see here is the required action against each risk level. Now, these aren't mandated anywhere. This would change from organisation to organisation, and even in the international standards, they don't mandate what exactly should happen. So it's up to the organisation concerned to ensure, and you need to put this in the privacy impact assessment, what action would take against each risk level. So you can see there, for a high risk, immediate treatment required, this should be addressed as soon as practicable. Whereas a low risk, you might do that you might manage by normal procedures and look at it on your yearly audit. Now, some agencies might wish to apply the Australian Government Protective Security Governance Guidelines, where you can see we have very high risks and very low risks. Again, it's a different matrix, but the idea of the risk is the same. It's the consequence and likelihood that determine what the levels of risk is going to be. Having done that, the step here is the checking the APP compliance. So you've got all these risks. Now you need to go through and check and say, am I compliant with the law? Have I reduced these to a level which ensures that I'm not breaking the privacy principles and I'm meeting the expectations of the Privacy Act? And again, here we can say yes, needs improving, or it's not applicable. There are cases when it won't be applicable to your particular project. And from this, a report can be generated. And here's some examples of different levels of detail. I mean, if you decide that just to do a threshold and privacy impact doesn't apply, then it could be a fairly short document. You might just have a brief PIA because you're going to find that it's not worth, the risks are too high, we shouldn't proceed forward. And so there's no point, you're effectively dismissing this project as being a viable option. And you have very concise or comprehensive and detailed. But in most cases, a summary is important because that might be something that you want to show to the public, that you've undertaken the correct procedures you don't necessarily want to show all the details and, of course, all your vulnerabilities. So that particular case study that we looked at, youronlinefriends.com, they were commended for their approach to privacy, in particular the time given by the professionalism of their staff. So this is not unusual. My consultancies, I often find this is the case. All the necessary information available to carry out the powers applied. People are usually quite willing, not necessarily to start with, but once they understand that this is not something that's going to become public, they will provide the information that's required. Of course, without it, it's very hard to do a PIA that's going to be successful. Although further information from the third-party IT service provider was not forthcoming, this has been identified high-level risk. So they have to think about whether they should continue to use that organisation or whether they should push their organisation to ensure they get the documentation that's required. The PIAs had discovered 4 high-level privacy risks in total that need to be addressed in the short term, certainly no longer than 3 months. A further 14 medium risks were identified that should be done in the short to medium term. If you can do them, some things are like low-hanging fruit, you can do them straight away, they're obvious. Other things might take a little more time to implement. And 2 low-level risks were identified that should be addressed in the medium term. So the majority of the risks are in the category of security of personal information, which is covered by Australian Privacy Principle number 11. They was recognised as an ongoing area of concern for all internet-based businesses and not untypical for many of the small to medium enterprises, yet they do present an unnecessary risk exposure that can be readily addressed. The PIA found that the project is viable and if proceeded with will not present an unacceptable privacy risk, providing the recommendations given in this report are followed. So you need some evidence that the recommendations have been followed to show that it's not been just understood. In fact, one of the problems I often have in doing a PIA is that as you discuss things with the customer, the client concerned, they start to realise that they have a vulnerability, and then they go and try and fix it straight away to make sure it's that problem goes away. And so when the PIA report comes in, they say, "Oh no, that's not a problem." But of course, that's not necessarily the best answer, because you need documentation of knowing what, you should document that there's a problem there, and you should document how it was fixed and whether that brings the risk down to an acceptable level, rather than trying to brush it under the carpet, because that's where things tend to go wrong further down the track. So to be considered currently compliant with the Australian privacy principles, this project was, and best practice for internet-based services. We can't protect fully, we can only do the best we can, and they were doing the best they could for the organisation concerned, and it would have been acceptable. Knowledge and practice change over time, and regular audits and updates are necessary to ensure ongoing compliance. This isn't just a tick box, we've done it. It needs a continuous ongoing audit to ensure that compliance is maintained. Things change. As we see the laws changing, are they now going to be compliant with that new law? And it was recommended that results of this privacy impact assessment would be published in an abridged form with some of the detail left out, but just to show what procedure was followed and how the organisation is addressing those concerns. Now, I mentioned the guidelines. Well, the Australian Guidelines for the Protection of Health Information from HISA is a very comprehensive document that covers all aspects, but for the particular things I've been showing here, or the spreadsheets, or the forms in these ebooks, and please have a look, one on privacy policy, one on privacy impact assessment, the privacy risk analysis, and a more recent one on cloud risk analysis. So they include the checklists, the spreadsheets, uses non-technical jargon, and it's aimed at Australian businesses. To find this, simply go to helpmeprivacy.com and look at the guidelines. So I'll move over these 2 slides and look at the way forward is ensure your organisation is privacy compliant with the APPs and take a holistic view on privacy. Don't just consider, look at the wider issues. And to do that, do a privacy impact assessment, which is what we've been studying, what we've been looking at in detail in this presentation. Follow a privacy by design approach. Don't try and bolt things on afterwards. Report any breaches now promptly, and this now can become a mandatory requirement. Don't think about social apps and check what you're committing yourself to with things. So in this particular case, it was considered this was more than just a social app, but it was a serious business. But many people do provide information without that they don't need to. So don't give out information you don't need to or want to. Quite often I ask to fill in forms online, and I just put in garbage if I don't think it's necessary for them to know that information. So you take control of your personal information wherever